Good evening, ladies and gentlemen. I'd like to call to order our Planning Commission meeting of January 25th, 2010. Please join with me in saying the Pledge of Allegiance as we begin our meeting. All right. Lilia, would you please call the roll?
Commissioner Adam?
Here.
Commissioner Fisher?
Here.
Commissioner Grumney?
Here.
Commissioner Reynolds? Here. Chair Lund?
Here. Now is the time for public comments, and this is the time that the public are invited to the forum to speak to us this evening on items that are within the purview of the Commission, but are not on the agenda for this evening, and we do not have any public comments, if I'm correct here. Thank you very much. So we move over to we have minutes for number 5. I have a motion. Commissioner Reynolds.
I move approval of the minutes of December 14th, 2009.
Comments? Please vote.
Motion passed 5-0.
It is with great sorrow that I turn over item number 6, Mr. Town, in absence of a motion to table this to you, Mr. Town.
Thank you, Chairman Lund. This is the first meeting of the year, and so I would like to, at this time, open nominations for Planning Commission Chair for the year 2010. Commissioner Fisher?
Yes, I'd like to nominate Commissioner Grumney for Chair of the Planning Commission.
Are there any other nominations? Great, hearing none. Nominations are closed. Would you please vote?
Motion passed 5-0.
And I guess in my last final act on the diocese chair, I'll ask for the nominations for Vice Chair. Commissioner Grumney.
I would like to nominate for Vice Chair Commissioner Al Adams.
Comments to the motion? Very well. Please vote.
Motion passed 4-0 with Commissioner Adam abstaining. No? Okay. Everybody clear it and vote again.
Please vote one more time.
Motion passed 5-0.
Thank you very much. Congratulations, Commissioner Grumney, Chair Grumney now. And if you just bear with us for a few moments, we're going to reorganize here and continue on with tonight's business.
If the Commission would like to make any comments, Commissioner Adams.
Yes, well, I'd like to congratulate Commissioner Grumney on being appointed as our chair, and I'd like to thank Mark Lund for the great job he did as our chair over the last year. You know, Mark, you kept the meetings in order, you kept them flowing along, you were respectful to all the residents, respectful to us, and even would intersperse it with a little self-deprecating humor now and then, which was pleasant. So again, you know, it's not easy being the chair and being a commissioner at the same time, and you managed to do the balancing act, and you did it well, and I'd like to thank you for that.
Thank you, Madam Chair.
Any other comments? Commissioner Reynolds.
And I also would like to congratulate Commissioner Grumney. I know that you'll do a great job, and Commissioner Adam on being vice chair, and I want to thank Commissioner Lund for the leadership he's given us this last year. And very good luck to you in the future, too.
Thank you.
And Commissioner Fisher?
Yes, I'd like to congratulate the new Chair Grumney. Looking forward to seeing a pretty face at the chair's seat, and to Vice Chair Commissioner Adam, congratulations, and look forward to a new year. And thank you to my good-looking friend to my right. Ran a great meeting. I think you've actually got the record for shortest meeting so far. So be a tough act to follow.
Thank you, Barry. Madam
And
Chair.
finally, Commissioner Lund.
Thank you. I just wanted to thank my fellow commissioners for my first night. We dealt with the Home Depot project here, which is a very big project, which I want to thank the Community Development Department for initiating me with trial by fire. And it's been a good year, and I appreciate being able to serve. I want to extend my congratulations to you, Chair Grumley. You'll do a great job. I feel sorry for Barry having to sit next to me now after having been able to sit next to you for this past year. Commissioner Adam, we're looking forward to your leadership also as Vice Chair, and congratulations to you. And I think we should get down to business.
Well, I just wanted to make a couple comments before we begin. And first, Commissioner Lund, I just want to also thank you for a wonderful year and how you have served for your community. You were always respectful and fair to the public, and we were lucky to have you. You also added a lot of humor, which I think was very important to make those people who come down here who feel quite nervous very relaxed. So we're, very lucky to have you. I'm sorry to be following you.
You'll be great. Thank you very
also,
much.
I would like to express to all of the planning commissioners that I'm going to do my very best as chair of this commission to follow in the steps of those that came before me, again, of being respectful to the public to try and do the best job possible. And so ready to kind of begin and move this forward. Oh, and one last thing. I'd like to just mention to my son Colin that he needs to now go home and complete his homework and brush your teeth, and I'll see you when I get home. Okay, now, Mr. Town, are there any announcements or continuances that you'd like to make at this time?
Thank you, Chair Grumney. There is a supplemental packet for tonight's meeting. We have additional correspondence with regard to Case 8A, that is the Living Oaks Community Church, another agreement for off-site parking to complement the one that's already in your packet. And then secondly, 2 minor changes to conditions for the landmark tree permit. These are changes to conditions 60 and 65. And that's all I had at this time. Thank you.
Will the Secretary please call case number 8A?
Hearing advertised as required by law is hereby open to consider agenda item 8A, case SUMJ 2009-70375, LTP 2009-70452. Applicant, Living Oaks Community Church. Request to allow the expansion of existing sanctuary space at 1033 Business Center Circle, to allow the conversion of an industrial building to church classrooms at 1077 Business Center Circle, to allow the conversion of an industrial building to church offices and meeting rooms at 1100 Business Center Circle, and to allow the encroachment into the protected zone of one sycamore tree to accommodate a proposed sidewalk. Location, 1033, 1077, and 1100 Business Center Circle.
Thank you very much. The staff report this evening will be given by Mr. Matt Chang.
Good evening, Chair Grumley and members of the Commission. If you can turn your attention to the PowerPoint presentation in front of you. And what's before you tonight is applicant by Living Oaks Community Church, and the project location is at, as you can see from this map, is 1033, 1077, and 1100 Business Center Circle. And what the applicant proposed to do is, I'll use this map, will be easier to describe it. For 1033 Business Center Circle, what they have existing is, they do have existing sanctuary space. And what they propose for this one is to expand the existing sanctuary space. And for 1077, what they propose to do is to convert warehouse as well as office to a classroom for educational purposes. And for 1100 Business Center Circle, and currently the applicant is using half of this building as an office. And what they propose to do is using lease the entire building for office as well as to conduct occasional meetings or class. In addition, this major modification, the applicant is requesting to allow the alternate use of parking facilities, and those locations will be from 975, 1000, and also 1125 Business Center Circle. As you can see from this picture here, is adjacent to the 3 leasing building that church is planning to use. And this is the summary of what the applicant is proposing to do, which staff has already described in the previous slide. In addition, the applicant is requesting a landmark tree permit, and the purpose of a landmark tree permit is to allow the encroachment into the protected zone of one landmark tree, which is California Sycamore, to accommodate the construction of a proposed sidewalk in front of 1033 Business Center Circle. And for background information, back in 1980, track as well as a special use permit application was approved for the subdivision into 7 industrial lots. And during that process, a master plan for the industrial park was also approved. And the existing church, Living Oaks Community Church, was approved back in 2005 by Planning Commission through the Special Use Permit Application 2004-71580, and the location's at 1033 Business Center Circle. And at that time, the approval also includes the alternate use for parking, which include 162 parking spaces, and the location at 975, 1077, 1100, as well as 1125 Business Center Circle. This is the picture of the existing church location, and what the applicant proposes to do for this location is to expand the sanctuary space inside the building, and there's no exterior changes proposed for this location. For this location, the applicant is proposed to convert the office and warehouse into classroom, and the applicant also plans to change the exterior door by change the single door into a double door, as well remove the 2 loading door to the back of the building. And for this address, the applicants intended to lease the entire building for office as well as for meeting room as well as a classroom use, and there are no exterior changes at this address. And this is the summary of the design, what the applicant is proposing to do based on the submitted report. And in addition, at 1077 Business Center Circle, the applicant is proposing to add a new trash enclosure to the back of the lot. Like staff previously mentioned, back in 2005, a shared parking agreement was approved, and the number was provided to you, so you can look at the existing shared parking agreement, and the total parking spaces will be 162, and that doesn't even include the church location they're currently using. And at this time, staff at Oso City is not aware of any problem that exists with the current church operation. And for future demand, the total required space based on the municipal code is 300 spaces. And this is a breakdown of a different address and also what they plan to do at different location. And the maximum capacity based on the schedule of activity submitted by the applicant require them to have 300 parking spaces. The applicant did submit a schedule of activity as well as parking study as part of the exhibit for your review. And this the proposed shared parking spaces. From this table you can see church are planning to lease 3 properties as well as using 3 off-site parking, which provide a total of 306 parking spaces. And the difference between the proposed use as compared to the one back in 2005 is additional 115 parking spaces. And the total parking spaces of 306 the applicant is providing will meet the required 300 spaces. Staff has evaluated this project and recommending approval of the parking as well as the alternate use of parking based on the following findings. Number 1 is, since church is planning to use, this is the peak time for the church use is actually on Sunday. And since other businesses are closed on Sunday as well, staff does not believe there will be a traffic demand for the parking spaces. So the conflict between parking demand will be very unlikely. And the second point is that the applicant is providing 306 parking spaces, which meet the required 300 spaces. Number 3. Currently, church is planning to lease 3 buildings, which provide a total of 131 parking spaces. And it is staff's opinion, as well as according to the letter submitted by the applicant, those 131 spaces are actually sufficient for the activity conducted during 8 to 6 p.m. Monday to Saturday. And those activities including office use, occasional educational classes, or occasional meetings. But they do provide 131 spaces, which staff believe it will be sufficient to provide that. And number 4, the alternate use parking agreement is effective after 6 p.m. from Monday to Saturday. And staff estimated that parking demand will be around 85 spaces, but as a backup plan that a total of 306 parking spaces will be available just in case the church do need that many spaces. And lastly, staff has imposed conditions in listening the staff report to require the applicant to notify the city any changes to the uses or any changes to the parking agreement, so city will be able to track of what's going on with the church as well as the activity to try to minimize any type of potential parking or traffic impact this approval might bring. In addition to the major modification, the applicant is submitting a landmark tree permit, and this is the subject tree, tree number 4, which is in the middle of your picture to the left-hand side of the sign, and this is a California sycamore tree. And the reason for the filing the permit because a proposed sidewalk will encroach into that sycamore tree. And the location of the sidewalk will be proposed in front of a 1033 Business Center Circle as well as part of 1077. And the purpose of a sidewalk is to provide a pedestrian access, because usually, typically, for example, on Sunday, there will be a lot of cars in and out of that street, and some people do park on the street. Having a sidewalk along the in front of the property will provide safer and easier access for people to walk on a sidewalk, because currently Business Center Circle does not have a sidewalk along both sides of the street. And for the sidewalk proposed, design of the sidewalk still need to submitted and reviewed by our Public Works Department. And staff has reviewed the landmark tree permit and is recommending approval based on the following. First, sidewalks provide a safe pedestrian access. Like staff mentioned, currently there are no sidewalk existing. So having a sidewalk will be provide easier as well as safer access for people to walk to go to the different locations, and as well try to minimize the impact between the traffic and also reduce the potential conflict. And second, there are design alternatives as mentioned by the applicant in the Tree report, that there are different design alternatives such as the paving system as well as the different design path location-wise that staff can explore. And the purpose of that will be try to minimize the damage to the landmark tree and try to save the tree. And third point is the granting of this permit will allow the applicant a reasonable use of the property. And for environmental review, this project is exempt from the Sycamore guideline as a minor alteration to the existing structure or operation. And in conclusion, staff's recommending the Planning Commission to approve this project based on the findings and subject to the conditions detailed in the staff report. This concludes staff's presentation, and staff's ready for any question.
Are there any questions of staff? Commissioner Reynolds.
Thank you. Good evening. I want to talk about the sidewalk. I noticed that there are trees there, there's a fire hydrant, there's a red pipe. Will the sidewalk be straight down along, or will it be kind of a meandering one?
Yes, currently there's several trees as well, fire hydrant. The final design still need to be submitted to the community development as well public works department based on the width of the sidewalk as well as the location of the sidewalk. So and the final design hasn't been finalized yet. And what staff is trying to do is try to avoid the tree as well as the hydrant to provide safer access, but as well as try to preserve the current hydrant as well as the tree. And that's what staff's intending to do.
And I would assume the sidewalk will meet the ADA requirements?
Yes, any final sidewalk design will need to meet the ADA requirements.
I only worry because I know that not always, if you have a handicap placard, can you find a handicap spot to park. And so therefore people might be coming down the sidewalk using a walker or a wheelchair, and not always is it easy to get around fire hydrants and different things. So that was my main concern. The sidewalk. Okay, thank you.
Commissioner Adams.
Thank you. Hi, Mr. Chang. How are you doing? Okay, just a couple questions, if I may. On the parking business, in the packet there's a letter signed by the owners of Building 1000 and the applicant. Are there letters in the progress for the other two buildings, or where do we stand on that?
As a part of the supplemental package, the applicant did sign and also submit the parking agreement between the other two property, which is 975 as well as 1125 as the part of our supplemental package.
Okay. It'll teach me to read my supplemental packet. Okay, then that's not going to be an issue. I just want to talk to you for a minute about the trees. So we're encroaching on tree number 4, which is a landmark tree. Tree number 2 is not a landmark tree, but why wouldn't we be encroaching on 1, 3, and 5? Aren't they landmark trees?
City has sent our city consultant to go out there to verify what kind of species they are, and actually staffs were out there twice to verify, to double check. And after careful evaluations, only tree number 4 was a sycamore tree, which by city code and definition, it does need a permit if there's encroachment. So for tree number 1, 2, 3, and 5, is not protected according to city guidelines.
Really? Okay. All right, well, that wasn't clear to me in the packet. It had said that 2 wasn't a landmark tree, but it didn't say about 1, 3, and 5. So only 4 is a landmark sycamore tree then?
Yes.
Okay. All righty. Let me just ask you, on the wording in condition 37 here. It's on page 17. It says, in the lower part of the paragraph, the use of alternative pavement material shall be considered based on submittal proposed materials to the city engineer. I think I know what you're trying to say there, but I'm not sure of that. I mean, it's not going to be considered. We're going to do it, right?
What that conditions provide more flexibility. We do, the whole intent is to preserve the tree and try to explore different design alternative. I guess the way the condition written is be flexible. But our intention is to preserve the tree and try to explore any paving system that will protect the tree.
No, I understand. I appreciate that. Maybe the word should be, instead of considered, it shall be used. Because condition 63 says that the mitigation measures in the tree report will be adopted and executed by the city. But then 37 says we're going to consider porous. I think what you probably meant was consider different types of porous and pavement, but I don't know, it just seemed unclear to me. Maybe that word considered should be used. But I can interject that, I guess, at the end.
Perhaps I could just add a few comments as well. The wording is that way simply because we don't know the final design of the sidewalk, but the intent of staff and the city and the applicant is to use pervious paving. So to specify it now would be a little premature, but it's certainly the intent of both the city and the applicant to use pervious paving to obviously allow rainfall and so forth to infiltrate into the soil and minimize the impact of the tree. Also, just quickly while we're on the topic of that tree, the issue of which trees are protected and which are not is sort of a long-standing issue of identification. In Thousand Oaks, we have two species of trees that in many ways look very similar. One is the California Sycamore, which is Platanus racemosa, and the other one is the London plane tree, which is Platanus serifolia. And so that is the reason why we, again, went out there to double-check the identification, found out that tree number 2 was, in fact, a serifolia and not the racemosa, not the California sycamore. And so that's why we're only talking about the one tree number 4 right now.
Okay, I understand. And I do understand the intent completely. It just seemed a little ambiguous there about we're going to either consider it or we're actually going to do it. So I still think we ought to use the word used there, but, and I understand you want to have the flexibility of what pavers you would use, and that, I understand that completely. Just one other thing about the tree. In the tree report, it talked about different options, and it said that, you know, the city was going to do option 1 and option 2, I believe, which is in fact the permeable sidewalk with the 12-inch base, deep base. Would option 4 be superior because it has less of a base, or would that somehow jeopardize the sidewalk? I mean, as far as keeping the tree intact. Option 4 says you'd have the permeable sidewalk, but the base would not necessarily be 12 inches in depth, and that would avoid some roots potentially.
Yeah, there are different options that staff can look at it, because as a part of review, staff will need to talk to our city landscape consultant as well as public works department to figure out a design that's can satisfy different parties and as well as preserve the trees. So that's why staff was saying that the final design hasn't been finalized yet, because there are different aspects that staffs are looking at when we're going to look at the final.
All right. So then there will be some flexibility there. Because in the tree report it said the city has adopted option 1 and 2, but what you're saying to me is this will be, flexible, and if for the health of the tree, we might go with that option 4 and not dig as deep, right?
We haven't finalized the final design of the sidewalk yet, so.
All right. Okay. Oh, and just one other thing. I mean, in the tree report too, it talks about the roots and how they could potentially damage the sidewalk. On Westlake Boulevard, I think they have a big long row of sycamore trees with the same problem. And I had never seen this before, but I jog along there. They actually put in rubberized sidewalks, because presumably because they would be, give a little if the roots came. Is that something that you've potentially considered?
Yes, there are different alternatives, and also applicant will give staff a different alternative to look at it. And staff will choose the best design that will maintain the sidewalk, and also try to preserve the tree, and also not to damage the sidewalk in the meantime as well. So we try to create a win-win situation.
Okay, that's good. So you'll look at that rubberized, because when you walk on them, you kind of bounce along too. It's kind of fun. Okay, thanks, Mr. Chang.
Okay, are there any other questions? If not, we will go to our applicant. Our main speaker is Stephen, I believe I'm going to pronounce it right, Jeffrion. And then we also have Dan Miller, who is available for questions. Good evening. If you wouldn't mind, please state your name and your city of residence.
There it is. Thank you very much, Madam Chair, and that was an excellent pronunciation. Thank you. My name is Steve Jeffrion. I'm with Lauterbach Associate Architects. I'm here representing the applicant, who is Living Oaks Church, and I live in Newbury Park at 208 Canyon Road. And we are very excited to be here this evening to bring this project to you. The church has been at this particular site for 4 years. And just for clarification purposes, the church has been utilizing the reciprocal parking that has at this facility for all that time frame. We have not created anything new. We've just updated the agreements to reflect what it is that we're doing right now. So that has always been in place and will remain in place. Regarding the sidewalk, yes, there is some flexibility there. We have looked at the rubber as an option. That was our original choice. But in looking at the pervious pavement, we believe that that would be better, actually a pervious block in terms of pavers. And we will be working with the city on a design and with our landscape architect to work with it so that we can provide the safest and best path of travel that we can to connect these two buildings. Our main focus at the church is safety, and we have that as our highest standard for both the traffic and for the pedestrian traffic. At this time, we'd like to present a video that the church has put together that gives you a better understanding of what this project is, and at this time, I'd like to have Matt run that for you.
If can switch the screen to the, thanks.
There we go. This is inside of the new Children's Worship Center, or the Children's Center. This is the lobby area, looking down with art display wall. The building is divided into basically two components, one for the younger kids. This is for the toddlers, one of the typical classrooms we have in there. And the other portion of the building will be for the junior high kids and for the high school students. This is another one of the classrooms that will be used for the younger kids. This is one of the resource rooms that will be available for all the instructors. Our second grade classroom. We provide a little kitchen that will be able to service food to the kids during their break times. This is one of our flexible classrooms where we have divided it into a series of different rooms for flexibility, all maintaining for the classrooms for different events that they may have in there. So we have our third and fourth grade classrooms. On the other half of the building is divided up into the junior high. This is our fifth and sixth grade classrooms. Oh, I take that back. I didn't get to junior high yet. This is our junior high area. This is a larger room. It also provides for music, for entertainment for the kids, our break areas. Place for them to do their worship. In our high school room, we have similar setup where they have a performance area for the kids to worship, and we have a area for them to do their lounge and socializing as well. This is a portion of that same room where it's set up with couches, entertainment for the kids. We also have a storage area to be able to store all the chairs, and we have a break room for the staff as well. So in conclusion, I'm here to answer any questions you may have. We also have representatives from the church if there are questions for them, but we'll save it for me. If there's anything I can't answer, I'll leave it to the professionals.
Are there any questions? Commissioner Lund.
Thank you. Good evening. Thanks for coming down tonight, sir. Can you describe for us, I'm very familiar with the operation that occurs there and the unique parking arrangements and the shuffle that goes on, particularly during hours of service. The outreach to the neighbors, you've obviously talked to the folks surrounding this property. Could you give the commission kind of an idea as to that outreach that was conducted?
Well, the neighborhood, I mean, it's an industrial neighborhood, so that the neighbors that we have are basically the tenants that occupy the existing industrial buildings. As you can see, as evident through the parking agreements, we've reached out to them, and they've continued to honor those parking agreements with us, and we continue to work with them as we have the ongoing needs of the church.
Thank you very much.
Any other questions? Oh, if not, we will thank you very much. We'll go back to city staff.
Very good.
Well, let me just check one thing. I also had, for questions only, Dan Miller. Can you come to the podium? If you could state your name and city resident.
My name is Dan Miller, and I'm a resident of Newberry Park, 3787 Calle Posadas. I'm the executive pastor for the church and pretty much the project manager for the project.
Are there any questions? I have just one. I'm curious, how large is your congregation?
Right now, we average about 1,000 to 1,050 on a Sunday.
Okay, thank you. Okay, now we'll go back to city staff for any comments. Mr. Chang?
Staff has no comment at this time.
Okay, and so then we go back to our applicant. Do you have any additional remarks that you'd like to make? Okay. And then we do have one statement card that's from Ron Hughes, who's in favor of the project. Okay, so now we will close the hearing and open it up for commission discussion and/or motion. Commissioner Reynolds.
Thank you. I think this is a very good use, and I like to see where the neighbors are helping out the other businesses. We've done this before, and it's worked well, and I think as long as it's monitored, in case a business happens to open on Sunday, which I doubt very much being an industrial area, that with that, I will move approval of SUMJ 2009-70375 and the landmark tree permit 2009-70452 with the conditions and findings as in the report and the revision of condition number 60 and 65.
Comments to the motion? Commissioner Fisher?
Yes, I'll support the motion. I think this is a very reasonable request, and it seems like we were just here yesterday with an application. It's nice to see the congregation growing in the area, so looks like a great project.
Commissioner Lund?
I just want to echo the comments and support Commissioner Reynolds' motion. This is a good example of how neighbors work together, and there's certainly a need that's been demonstrated here, and you have been good neighbors there, and this is something that I'm personally very happy to support, and congratulations to you.
And Commissioner Adams?
Yeah, I support the motion as well. The sidewalk is a must. It's a safety issue. You got to have a sidewalk there, no question about it. The city's right in requiring it, and I think there's been enough, what's the word, sensitivity, emphasis that you'll do your best to preserve that sycamore tree, and shared parking works well. We use that at our church. It's been going fine, so I'll support the motion. Thanks.
And back to Commissioner Reynolds. Any further comments? Okay, if not, could you please vote?
Motion passed 5-0.
Okay, will the Secretary please call case number 8B?
Hearing advertised as required by law is hereby open to consider agenda item 8B, case MCA 2009-70100. Applicant, City of Thousand Oaks, request municipal code amendment to consider changes to the Oak Tree Protection Ordinance and corresponding policy resolution. Location, citywide.
Thank you very much. The staff report this evening will be given by Stephen Kearns. Good evening, Mr. Kearns.
Good evening, Chair Grumney, members of the Commission. As mentioned, the item before you this evening is a municipal code amendment pertaining to the Oak Tree Protection and Preservation Guidelines. This request involves consideration of amending both the Oak Tree Ordinance as well as the Oak Tree Preservation and Protection Policy Resolution. The purpose of this amendment is to consider simplifying the Oak Tree review procedures as well as the protection standards, and to consider providing an exemption from the protection standards for owner-planted oak trees. To give you a brief background, in 1970, the city's first Oak Tree Ordinance went into effect. In 1987, the Oak Tree Preservation and Protection Policy Resolution went into effect. The intent of this resolution was to provide implementation standards to protect oak trees during a period in which there was quite a bit of development in the city. And it also established a tree replacement program. So if a tree had to be removed to accommodate reasonable use of a property, replacement trees were then required to offset that loss. In 2003, the Residents' Roundtable was authorized to study the Oak Tree Ordinance. In 2006, the City Council initiated, or Residents' Roundtable recommended initiation of a municipal code amendment. The amendment was initiated to formally consider exempting homeowner-planted trees. This amendment was presented to the Planning Commission in 2007. And after considering the item, the Planning Commission recommended against the exemption to the City Council. In October of 2007, the Planning Commission's recommendation on the amendment was presented to City Council. After considering the item and listening to public comment, City Council directed staff to widen the scope of the oak tree ordinance review to include all zoning categories, as well as the idea of exempting owner-planted trees. In May of this year, City Council initiated this municipal code amendment, and on December 14th, at your last meeting, the Planning Commission considered this item. They agreed with you agreed with portions of the amendment, but wanted further information on the potential for exempting homeowner-planted trees. Just as an overview, very briefly, of the protection standards, oak trees become protected once they reach 2 inches in diameter at 4.5 feet above the tree's natural grade. All species of quercus are protected, which includes not only the indigenous species, but the non-indigenous as well. This slide is a picture of a tree, just to give you an idea of what a tree that just reaches protection, what it looks like. Now, at the December 14th meeting, the Commission agreed with the concept of the proposed procedural changes and the additional exemptions. Just to summarize these exemptions, these changes, additional exemptions from the protection standards that would not require a city permit, such as clearance pruning of branches less than 2 inches in diameter over driveways, walkways, or streets. Clearance prunings were also defined, such as 8 feet from structures, 7 feet 6 above walkways, and 16 feet above the streets. Those are maximum pruning standards. In addition to the exemptions, new permit types were proposed. Type A permit would be used for authorizing the removal of dead or hazardous trees. Type B permits would authorize minor encroachments and pruning of branches greater than 2 inches in diameter. This application type also has a reduced filing fee, and it doesn't require an oak tree permit or report prepared by the applicant's consultant. The Type C and Type D applications were solely a change in title. The review procedures and application submittal requirements did not change. The Type C would be for more significant activity than the Type D permit, and it can be considered administratively. For such requests as removal of 3 or less than 3 trees, 3 or less. Type D applications would be for more significant requests that cannot be processed administratively and would require Planning Commission consideration. Staff proposed establishment of a new oak tree maintenance program. This would allow owners of oak trees to perform approved work over a period of time authorized by this program. This program would benefit an applicant as it eliminates the need for a new permit each time a tree is in need of maintenance. And staff was proposing to eliminate redundant text and moving appropriate language from the resolution to the municipal code. There were staff is providing 5 options for the Commission to consider. These are: 1, providing a blanket exemption for owner-planted trees with no city procedural requirement; establishing a new permit type for determining whether or not a tree was planted by an owner or grew there otherwise; establishment of a tree registration system for owner-planted trees. 4 was utilizing a hybrid of options 2 and 3, which would include both the permit process as well as the registration database. And option number 5 would be do not distinguish between owner-planted and native trees and provide no exemption of owner-planted trees. Option 1 is to exempt the owner-planted trees with no procedural requirement. The advantages of this option are that there would be no permit requirement for the owner of a tree, which could result in the planting of more trees or encourage owners to plant a tree since they wouldn't fall under protection. The disadvantages is that there is a potential for removal of native trees with the potential claim that it was planted, and it put the city in a reactive mode where we'd be responding solely to complaints. So a neighbor sees someone cutting a tree, and then they'd call the city, and we'd have to investigate at that point. Option 2 is establishing a permit procedure, which would be a new type of permit, a Type E permit. This would involve a homeowner submitting an application for exemption from the protection standards for an existing tree. And then staff would evaluate data such as the aerial photographs, look at the site conditions, the surrounding environment. Is it an area where there are several oak trees? And then try to guesstimate the age of a tree based on its size versus the age of the development. The advantages of this option are that it applies to trees that are existing, and since there would be a city review involved, it reduces the potential for the removal of native trees. The disadvantages are that it would be determining or distinguishing between a native tree and an owner-planted tree, at least with any certainty, is very difficult. And this option could also require significant staff time to evaluate and determine the status of a tree. Option 3 is establishing a registration system for contemplated plantings. In this case, a property owner would submit a plan depicting the location of the tree, bring in photographic evidence of the tree, and after the tree is actually in the ground, staff will go out there and verify it and store all this information and documentation under the property address. Advantages of this option are that owners of registered trees could perform work to and around the tree without any sort of procedural requirement from the city. And it could encourage the planting of trees, and there would be absolutely no question that the tree was owner-planted, since we would have had documentation showing that the tree is or was planted by the owner. Disadvantage of this option is that it's only forward-looking. It wouldn't address trees that have been developed or that are existing on a property right now that may have been owner-planted. Now, option 4 it's a hybrid approach. It's utilizing both options 2 and 3. It's combining the two concepts. We use a permit system to retroactively look at trees to determine if they were owner-planted or if they were protected as part of a development, as well as using that database, so it'd be both retroactive and proactive. The advantages are that it provides just that, the retroactive approach for to the permit procedure, and the registration system would remove any uncertainty of how a tree arrived in a certain location and was in fact owner planted. The disadvantages, it could involve substantial staff time to evaluate existing trees, and there is a potential of disagreement between the city and owners of trees due to the challenges associated with distinguishing between a native and a owner-planted tree. That's particularly even more difficult for larger trees. And option 5 before you involves providing no distinction or exemption of owner-planted trees and native trees. The advantages of this option is that it will maintain the current protection standards for all oak trees, and there'll be no ambiguity as to whether or not that tree was homeowner planted or if it was native. It just falls under the umbrella of one protection standard. This would eliminate any subjectivity by staff and the potential for disagreement between a property owner and the city. The disadvantages of this option are that trees that may have been planted by an owner for aesthetic purposes become protected once they reach 2 inches in diameter at 4.5 feet of oak grade. And anything they want to do to the tree at that point would require a city permit, as it does now. the permit itself and the application fees and report requirements could discourage, or may have discouraged, the planting of oak trees on private property. It's important to note on these the proposed options that are before you, none of these options would exempt trees that are part of an approved landscape plan, or street trees or trees in park sites or open space areas. This is solely for homeowner plant or owner planted trees, which the majority of these trees would be on single-family residential lots. Since this item is solely a change in policy and procedure, it does not qualify as a project, and it's exempt from CEQA. Staff is therefore recommending that the Planning Commission recommend approval of the proposed procedural changes and the additional exemptions, but do not recommend any of the exemption for owner-planted trees. So there'd be no distinction between owner-planted and native trees. However, should the Commission choose to go with one of the options that are before you tonight, staff would recommend the hybrid option, option 4, which is the permit approach and the database, so provide both the retroactive and proactive approach for reviewing these types of trees. And this concludes staff's presentation. Staff's available for any questions.
Thank you, Mr. Kern. Is there any questions? Commissioner Adams?
Thank you. Thank you. Just one question. How about that? It's been noted a number of times from the reports from last session as well as this one that the Residents' Roundtable came out in favor of exempting owner-planted trees from protection. So, in fact, I think I was the one who requested, could I see the minutes to that? So in attachment 5, that seems to be the minutes. But where does it say that in there? Unless I haven't interpreted it properly, I can't find that. I mean, I see recommendation 3, it says something about eliminate city review of changes to common area landscaping. But I just wasn't able to find where they definitively said we recommend that no protection to owner-planted trees, unless if that was something that just was more or less intangible that came out of the meeting.
Well, the summary notes for this meeting that is attached to your report, it's not all the minutes that were, they weren't actual minutes, they were summary notes that were just kind of capture the meeting and what was discussed. Several meetings before that there was items discussed. This started in 2003. It continued, it was tabled several times because other items came up, such as the RBs, which you got into, the home occupation permits, and other items that sort of sidetracked this. And during, I think it was about 8 meetings that they discussed this, they talked about several ways of exempting owner-planted trees, and they came up with an acreage under 1 acre in size, I believe. Any oak tree on that property, regardless of its status of homeowner planted or not, would be exempt from protection standard, and that didn't go forward and wasn't recommended by the roundtable.
Okay, well, you were in the meeting, so there was an interpretation issue. I just expected to see it in here somewhere, and I didn't, so that's why I asked. Thank you.
Any other questions? Commissioner Reynolds.
Good evening, Mr. Kearns. I don't know if this question is really for you or for Mr. Town, but several times it's mentioned about the staff time it would take to review everything if a tree is to be removed. I don't know what authority we have to really put that on staff to increase the staff time.
Well, we're not sure at this point how much staff time is actually going to be involved, because each case is going to be unique. It depends on several factors, law characteristics, what information we have for a particular development. If we have the track map, on the track map, does it show a tree that was in a restricted use area, so it would be preserved during the grading activity and development of the property, or other documentation that we have. So we don't have a good idea of how much time it's going to take, so it would be done sort of on a trial basis, and If it is substantial staff time at that point, we would, during the next fiscal year, we would adopt a fee to offset the time spent by staff.
Okay, and eventually permits could be appealed all the way to the Planning Commission too?
They could.
For removal. And also in your report, you talk about how neighbors would be notifying the city of somebody cutting down a tree, but I know I've called in over the years when I see someone cutting a tree down, and so I think that goes on all the time. Somebody that's very aware of the oak trees and they see someone cutting down a tree, and every time I've done that, I've always been told that it is a diseased tree. They did have a permit to remove the tree. So do you think that's going to be a lot of calls from people, more than what goes on now?
I wouldn't anticipate a significant difference in the number of complaints that we get. There may be more activity if one of these approaches or the other options are adopted, and it would be more of a community outreach thing where people, or residents need to be aware that there is a new exemption, the tree that he's cutting down, or pruning is actually a homeowner planted tree and does not qualify as protected by our standards.
Mm-hmm.
So,
and how do you plan to let everyone in the city know that if they plant a tree, if it's adopted, there's a new policy?
Well, there'd be the TOTV, the city's website, and the city staff is going to do a page on our city website dedicated to the care and maintenance and protection standards of oak trees. So it'd be accessible there, and of course, this being a new item would be, a link to it, and it'd be bold to jump out at you, so people would be aware that something new is happening to our ordinance.
And also in the city, seeing the newspaper or something like that, because I think that that's something that not everybody is aware and goes to the website, that it would take publicity in the city to let people know if there's a new ordinance regarding oak trees. But I can see where it would encourage homeowners to plant more trees if it's easier to remove. So, thank you.
Okay, and Mr. Town, did you have some additional remarks?
Thank you, Chair Grumney. Just a couple. Yes, we would get the word out if the commission, ultimately council, wanted to provide for some type of an exemption for owner-planted trees in the city's newsletter as well as on the web and through TOTV. Also, to address in part your previous question, the Planning Commission does have the right to make a recommendation that could result in additional staff time, and in this case to evaluate trees that a property owner would represent that they had planted in some way, or come into the city hall to register for future removal.
Okay, we have 3 speaker cards. The first speaker, Dave Gulbranson. If you could please come to the podium. If you could state your name and city of residence, and you'll have 5 minutes.
I'm Dave Gulbranson, 36 years a resident and property owner here in Thousand Oaks. I'm a member of the Thousand Oaks Boulevard Property Owners Association called TOBA, and until this article came out in the Star, we were unaware of all these changes going down with the oak tree ordinance. It impacts our members dramatically, and me in particular. For some reason, I've experienced more input from monument oak trees than probably any other property owner. I've had a 400-year-old oak tree topple, no one injured. Oak tree falls on the oldest home in Thousand Oaks, that was mine. Landlord applied to fell an oak tree and it fell. Oak tree tumbles in yard, misses kids by minutes. Our organization represents over 250 parcel owners on Thousand Oaks Boulevard. We would like to have a chance to input before you vote on such a dramatic change to the oak tree ordinance. We're business people, we're property owners. We tend to lean towards common sense in ordinance. Common sense, something that I think our federal government, state government, and hopefully not our city government has gotten away from. I think the current ordinance is onerous to property owners. We see oak tree saplings now, we remove them. We don't want them to grow 4 feet high, 2 inches in diameter. Because once they become that size, we don't own them anymore. The city of Thousand Oaks does. I applied for an oak tree permit. I paid over $10,000 for all the requirements to get a permit to take down a tree that was diseased, hollow, and overhanging 3 properties adjacent to mine. The oak tree consultant, who I think is biased in most cases towards the tree as opposed to the protection of property and people, said the tree, normally of that age, is hollow and has some rotted branches. I was allowed to deadwood it, which I did. 3 years later, the tree fell, split in 3 pieces, caused over $152,000 worth of damage. I was present when it fell. I've been present when 3 of them have collapsed. This sudden limb drop phenomena that happens in the summertime with these big monument oaks. The former mayor, Francis Prince, was on my back porch when it collapsed. Bob Majorino, the owner of Prudential California Realty, was standing near the tree when it collapsed. I was cited because I didn't remove the oak tree, and I never did get that permit. We did remove it. I did pay for all my neighbors' damages. My insurance covered about 1/5 of the cost. I brought suit against the city of Thousand Oaks. And in the ordinance, there is a section 5-14-8, non-liability to the city. I went through 3 demurs, and on the 4th one, it was kicked out of court. It says nothing in this ordinance or within the oak tree preservation and protection guidelines shall be deemed to impose any liability for damages or duty of care and maintenance upon the city or any of its employees. Great little piece of legislation. Our group would be very interested in incorporating a little more common sense into our oak tree protection, preservation, and oak tree ordinance. We have some very gifted people, lawyers, business people, property owners, who would be a valuable asset to add just a touch of common sense. I like oak trees. I like protecting oak trees. I think they're a beautiful addition to our city. I would hate to see the continued removal of beginning oak trees in our community. I'd like to see some incentive to plant more oak trees. They are a liability. If anyone would like to, I don't know if anyone on the commission has experienced one of these collapsing, but you're invited to come to any of my properties. I'm sure one will occur when you're there. And if you have any questions, I have a vast amount of experience with these oak trees, the permit process, the consultants, the surveyors, the parcel maps, and everything that's necessary to get a pruning done or an oak tree modification done or an oak tree planting. Thank you.
Are there any questions of the speaker? Okay, if not, our next speaker is James Dean. Mr. Dean, if you could state your name, city of origin, and you'll have 5 minutes.
Good evening, James Dean, landscape architect. I reside in Newbury Park. I'm here to support the changes to the ordinance. We've gone through 40-some-odd years of protection of the trees, and I think the city has done an excellent job, and so does the rest of the state, because the ordinances that started here are mirrored every place else. I'm the consultant, oak tree consultant to the city of Calabasas, and they have what's called a healthy oak tree permit, which was their way to simplify the process a little bit and honor the homeowners. And I want to give you all each, if I may. I'm in support of number 3. I think that one makes the most sense with some changes to it. I think simplifying the process for homeowners is a good thing. The healthy oak tree permit requirement in Calabasas is a person coming to the counter, filling out a form, and the city then sends me out. By the way, there's no fee for that. The city sends me out to take a look at the tree and assess the situation and write a memo to the city. They then issue a healthy oak tree permit. I think that's a real sensible way to do this, because what's going to happen when we simplify this process. Suddenly you're going to see probably 2 or 3 years of a lot of confusion, a lot of people calling, a lot of time from code enforcement, and et cetera. I think it makes a lot of sense. I would like to see a form. That particular one I sent to you is a form we made up for code enforcement. But I would recommend an initial form and make it very simple with checkoffs and handwritten information so the staff doesn't have to spend a lot of time. They don't have to get a consultant. And that gives you the initial record. I believe that even though it's exempt from, say, permits, I think that a person should then notify the city with another form similar to that with checks and et cetera. The more information we can gather about the trees, the more we tell the community that we're still concerned about the trees, and we haven't spent 40 years being really tough, and now suddenly 40 years of being really not tough. So I think that's what should happen. There's a couple more things I noticed in the Oak Tree Ordinance, that the fireman in the process of putting out a fire can allow a tree to be taken out, and I think that should be changed to any kind of emergency. I had a situation in Westlake where I just happened by and saw a huge oak tree with a split down the middle. Had that fallen, somebody could easily have been killed. And I think a fireman in that case called in a situation like that should have the ability to take immediate action to make it a safe condition without city problems. That would be my recommendation. There's a lot of professional people who have come out of this ordinance locally and through Southern California with a lot of experience on trees. The more we can get people to somehow employ those or somehow contact these people with knowledge, the less chances we have of the situation where the trees are falling. Our trees are very old. They're subject to exactly what he said. We had three oak trees, big, gigantic oak trees fall in a apartment complex, Oakview Apartments in Thousand Oaks, and that is a very major potential. That's why I think the professional people arborists should see the trees and should give an advice as to whether a tree is safe or not safe. That pretty much concludes what I had to say. I think it's long overdue. I had one particular case I complained a little bit about in Newbury Park, where a homeowner had to cut off 2 branches, one over a fireplace and the other one over his car. And before he was done, he spent $1,000 on fees, city fees and consultant fees and all that, and it took him a total of 15 minutes to cut the branches. So I think this is overdue. I think it's a good thing we're doing, and I support it.
Are there any questions of the speaker? Okay. If not, our last speaker is Judy Lazar. And if you don't mind, state your name and city of residence.
I'm quite used to it, although sometimes I forget. Judy Lazar, City of Thousand Oaks. I am a 40-year resident of the city. Well, I'm back again, and I'm surprised to be back again. Here, let me give you these. I'm here, of course, about the portion of the ordinance concerning homeowner-planted oak trees. I've reviewed the staff report, and I'm here really in support of what the Residents' Roundtable initiated about, 4 or 5 years ago, the recommendation regarding homeowner-planted oak trees. When I spoke at your meeting in December, when this item was last discussed, I proposed a method for permitting and removal of homeowner-planted trees. While that seemed to meet with considerable support from the Commission, the staff report before you again recommends that no changes be adopted to allow such removals. However, the staff has provided you with 5 alternatives. and I'm here to support one of them. I'm here to urge you to adopt Alternative 2, which would establish a permit process for the removal of owner-planted trees. And please note that although Recommendation 2 would require staff inspection and document review, staff does note that they do not believe that there would be a significant number of such requests. I would also like to point out that a current homeowner who is not the original or previous owner who may have planted the tree may not have the documentation that staff is looking for in terms of a receipt or a photo of somebody planting the tree. So you may have to rely on other information surrounding residents or even a homeowners association when appropriate. The process proposed by staff, I think, is relatively simple and allows for an appeal of an administrative hearing. I agree with the staff recommendation that if you adopt this option, it be on a trial basis and that it be reviewed after 2 years. I think that's eminently reasonable. You know, somewhere in the staff report it says that they contacted the surrounding cities and nobody else has done this. Well, so what? You know, the fact that nobody else has done this doesn't mean it should never be done. We can be the first to do it. You know, we are Thousand Oaks. We do believe in our oak trees. We do value them, but we also value our residents and their ability to use their property in a reasonable fashion. A couple of comments. Recommendation 3, while attractive in theory, and that's the one for establishing a database, I think is unlikely to ever be completed. Frankly, I don't know how many homeowners would register an oak tree that they plant by submitting a site plan and a photo and all that evidence. It's just, you know, realistically, that's not going to happen. It would do nothing to help the homeowner with an existing oak tree on his property. It's only a forward-looking measure, so it doesn't do anything for homeowner-planted oak trees. With regard to Recommendation 4, the hybrid one, it's not clear to me, and I don't think it's clear to anybody, whether the database would have to be established before a permit for removal could be issued. While I think it might be commendable, although somewhat bureaucratic and expensive, I don't know that such an inventory is really worthwhile. You know, it'd be nice to have it. You could certainly do it on an ongoing basis with new development. The hybrid approach, though, simply imposes further delays upon the homeowner's ability to remove their tree. Remember that this review began a long time ago. Let me point out a couple of little things. The Oak Tree Ordinance originally was adopted when the city was growing, when there was some threat of property owners cutting down oak trees in order to enhance their ability to develop a property. That's not the situation today. It really isn't. Most of our properties are developed. Many of these oak trees, you can figure out whether or not they're native or not. We have some 40,000 oaks. My God. You know, nobody is proposing to remove all of them or anything close to it, and our residents around other residents would be up in arms if that happened. The City Council recommended that we look at this. The Residents' Roundtable recommended that you look at this. A single note is that, you know, it occurs to me that most of the planted oak trees are holly oaks. They're not the coast live oaks, those beautiful, massive, dangerous oak trees in some cases, but the holly oaks can get quite large, but they are not. They are the ones that are usually planted by homeowners. I think it would be not as difficult as staff would like to make out to determine whether or not it's a native tree. Again, I urge you to adopt Alternative 2 and have a permit removal process for homeowner-planted oak trees. If you have any questions, I'll try to answer.
Are there questions of the speaker? If not, thank you.
Thank you.
Okay, we'll go back to staff for any comments.
Staff just has one comment on the, Mr. Dean mentioned the Healthy Oak Tree Permit, which is what the city of Calabasas uses. We tailored some of our recommendations based on that. That Type B permit is similar to what they use. The application form can be a checklist type form. We haven't come up with anything yet since nothing's been approved. And the idea of the dead or hazardous trees being removed by firemen or policemen or other agency. We do have a process in place for dead or hazardous trees. That type A permit will be used. We have our consultants that go out there, verify a tree is dead or in fact hazardous. So we do have a system in place now that does work. So that's all the comments I have.
And Mr. Town, do you have some comments?
Thank you, Chair Grumney. Couple with regard to Mr. Gobranson's request for continuance of this item in terms of the Planning Commission's action. I think Mr. Kearns can verify. Notice was sent out to TOBA. It was our understanding it was sent out, in fact, on multiple occasions. However, I should note that Mr. Gobranson did make comments at the City Council meeting at which this item was previously considered and at which time it was referred back to the Planning Commission for consideration. And it is within the Planning Commission's purview to continue this item if you would like the Thousand Oaks Boulevard Association to give it further or to give it consideration. So that is within your purview. Also, with regard to Mr. Gobranson's comments, again, I'm not sure if TOBA has had a chance to look at the 5 changes that Mr. Kearns outlined, not only in December but now, but the intent of those was to take a more common sense approach to oaks in the city, and I think that we are taking steps in that direction. Also, Ms. Lazar had a question about trees that would be registered and whether the property owner in such a scenario would have to come back to the city for approval to remove those trees in the future. The answer to that is no. Once it would be registered, then there would be no need to come back and secure any further city permits at that time. And that's all I had at this time. Thank you.
And prior to closing the hearing, I just want to make a statement to the public, just for a point of clarification, that what this body is doing is simply deciding if we would make a recommendation to the City Council. We don't make the decision on this final, it's the City Council that does. And with that, I'm going to close the public hearing and go for a discussion and or a motion. Commissioner Lunn.
Thank you. I want to start this out by saying, first of all, this process has been going on an awfully long time. The Residents Roundtable, our citizen counterparts here, volunteers in the city, have looked at this. City Council has given some direction. There's been an awful lot of great staff work that has been done by city staff to put this together. I want to commend you, Mr. Kearns, for your presentation tonight, the last Planning Commission meeting, and for all the work that went on behind the scenes putting this together. I think that for purposes of discussion, I believe that we need to take what the Residents Roundtable, and I think I stated this at the last Commission meeting, has recommended, what the City Council has put on top of it, and I think that we need to act tonight with our recommendation, and that is my intent. And so I'm going to move that we approve staff's recommendation number 1 in the report, and in terms of my motion for number 2, I'm going to recommend option 2, because I think that is as closely aligned to what the City Council's direction had been given and as to what the Residents Roundtable had found in terms of what they wanted to have done here. And with the proviso of that is nothing that we do in government should be, good government should be responsive to the changes in the community and changes in needs. I think that option number 2 most closely follows the direction given by our Residents Roundtable after careful analysis. It's also the least onerous in terms of all these options, in terms of city staff time and of residents' time. So it's the easiest thing to get accomplished. It also allows us to take a small bite out of this apple at a time, to take a look at it. I agree with one of the speakers here tonight. I think now that we are in 2010, that these protections of oak tree standards are tremendously onerous on property owners at this point in time. we are Thousand Oaks, as a speaker had mentioned, and we do protect our trees here, and it's very important. The forefathers of our city have thought that important to place those standards in place. I think it's time for us, and at least for my motion here, is to make this recommendation and move this forward.
Comments to the motion? Commissioner Reynolds?
Thank you. And I'm going to support that motion. I'm glad that you said option 2 because that's the one that I had wanted. Along with you, Commissioner Lunn, and Mrs. Lazar. Now I know why she was mayor of the city. I really think that times have changed since the original ordinance, and having had a friend that went through an awful lot trying to get a tree removed that was planted that was leaning on the roof and pushing a fence down, and it cost an awful lot for that person to pay for the oak tree report and everything else, that I think that we owe it to the citizens to make this recommendation to the City Council with option number 2.
Commissioner Adams?
Thank you. Well, I do think that the changes that staff has suggested and that we in fact embraced at the last meeting to the ordinances do go a long way into responding to what, the problems people have with oak trees. As far as Mr. Gulbranson, as a matter of fact, this new permit process that's been suggested, for the removal of a tree that is confirmed either dead, hazardous, or causing substantial physical damage, you would no longer need an oak tree report. It's called a Type A permit. In fact, it could be determined on-site by a city representative right there and then, and I think there's a nominal cost, or there may not be any. You could have that tree permitted to be removed. So you can remove a hazardous tree, a tree that's causing property damage, and I don't think you would go through what you've gone through in the past. And in fact, a lot of these ordinances changes have gotten a lot looser. I mean, we're talking about ground plane improvements, whereby you want to put a bench or some stones around the tree. You could do that now. That's exempt. Clearance, pruning, anything less than 2 inches, you can cut that without a permit, without an oak tree report. This oak tree maintenance program has been suggested, where you can get one permit to take care of a number of different trees instead of getting a permit for each tree. And again, removal of hazardous trees, trees that are dangerous, trees that are threatening property can be done. It can be done now. And being responsive to the public, I tell you, that 2004 attitude survey that the city spent a lot of money and put out there, 17% of the people said oak tree regulations should be eased. The other 82% that said they should stay the way they are or be more restrictive. And I know Ms. Lazar mentioned, well, we could be the first, but, I think the staff did the right thing. They queried different cities around the county. They even went outside of the county, Westlake Village, Agora, Calabasas. No one differentiates between homeowner-planted trees and indigenous trees. Now, maybe we could be the first to be a groundbreaker, but that says something to me that, that there's a precedent out there that the tree's the tree. And then again, the Planning Commission in 2007 also stated that there should not be an exemption for owner-planted tree. Well, that's what it said. I wasn't here in 07, but that's what it said in the staff report. And as I go through these options, and if I may, I'll try not to be too long-winded, but that option 1, where it'd just be a blanket option. You can take out the tree on a whim. If it's in your way or a view, to me, that threatens indigenous trees and could cause bad relations between neighbors. I have a neighbor, we have an oak tree, it's right on our property line, right? But it happens to be on their side. And she said to me many times, I'd love to take that tree out. I'd love to take that tree out. It's a 50-foot tree. It's beautiful. I wouldn't love to take that tree out, but she would. But there's other neighbors on my side that wouldn't want that tree out either. But I think it causes, but nobody seems to want option 1 anyway. So, and option 2, the permit process, you're talking staff time, you're talking more bureaucracy, and I think it could, especially with no fee involved, I think it could involve a kind of a frivolous attempt to try to maybe let's take a shot here and see if we can classify an indigenous tree as an owner planted, because there's no guarantee that the staff can tell the difference between the two. So the homeowner says, well, this is owner planted. It's on a slope. It's not that big. It could create a problem there, I think. And as far as the other options, option 3, I agree with you completely. I mean, we can't even get people to vote, much less register oak trees. I just don't see that happening. I don't see that happening. And option 4, this combo approach, that's really staff intensive, and we have a depleted staff at this time, and I just don't see that as a viable option. I mean, I like option 5. It's a personal responsibility option. Let's take personal responsibility for these trees. I mean, if you're going to plant a tree, you better be sure it's in the right place and you want it to be there. You don't expect government to step up and create this huge bureaucracy with permitting and registration and everything else to try to help you determine that, well, you can take that tree out. I mean, you planted it. So let's take responsibility for that. It's a personal responsibility type thing in my mind. So I'm all in favor of the ordinances that we tacitly agreed to last time, but I couldn't support the second part with the permit process number 2. I think we should go with this. I personally feel that we should go with the staff and not exempt owner planted trees.
Commissioner Fisher?
Well, I was on the commission in 2007, and my thought process hasn't changed since then. I do like the changes to the ordinance. I think it does provide a lot of flexibility and keeping safety in mind. But as back in 2007 and 2010 now, I think we should recommend to the City Council that we go with the change of ordinance. But as before, I'll stick with option 5. I don't believe there should be an exemption. It's going to be very subjective. It's going to be cumbersome, and I think we're headed down a slippery slope with that one. So, if anything, maybe consider cutting the review time of this whole process. Looking at some other type of options, but again, my opinion on this hasn't changed, but I do like the changes to the ordinance.
And Commissioner Lund, do you have any final comments?
I would only say that I was here in 2007 also, as I think all of us were at that point. So,
I think I was.
Were you here?
I got my chronology mixed up there.
My feelings at the time is, for my vote at that particular time, where it might seem to be in contrast to this evening, is the fact that I don't think that the staff report and the information that we had was as developed as it is this evening. And I think not that it was a bad report, it was a great report. I just don't think that we had the options, and there were some more things to look at. And so we have a more complete array of where to move. And so that's where I am with that, and I have no amendments to my motion.
Okay, if not, could you vote, please?
Motion failed. Commissioner Adam, Commissioner Grumney, and Commissioner Fisher voted no. Commissioner Reynolds and Commissioner Lund voted yes.
Okay, so now we're going to go to Mr. Town for any Community Development Department referrals and reports.
Well, before we do, are there any alternate motions for this item?
Oh, excuse me.
So we need a counter motion.
Okay. Are there any other motions, Commissioner Fisher?
Yes, I move approval of MCA 2009-70100, Oak Tree Ordinance and Resolution amendments as submitted in our packet.
That's it. That's right.
Is there any comments to the motion? If not, could we vote, please?
Motion passed 3-2. Commissioner Reynolds and Commissioner Lund voted no.
Okay, and again, that this is a recommendation to the City Council. The City Council will make the decision. Now we can go to Mr. Town Community Development Department referrals and reports.
Thank you, Chair Grumney. If I could direct the Commission's attention to page 143 of your packet. At this time, we do not have any hearings scheduled for February 8th or February 22nd, although there may be items added to the 22nd agenda. However, given that background, I would recommend at the conclusion of tonight's meeting that the meeting of February 8th be canceled, and we will keep the Commission informed as to agenda items for the 22nd. I should also note, as you can see, that we have a number of cases scheduled for March 8th and March 22nd. Great. With regard to items to be considered by the City Council or recently considered, the appeal of the Conejo Mobile Home Park closure item, which was denied by the Planning Commission in June of last year, will be considered at this time by the City Council on February 9th. That's the tentative date for that. And then also the Skelton Canyon wireless facility site is expected to be coming back to the City Council at a date yet to be determined, so that case is still pending. And that's all I had at this time. Thank you.
Are there any AB 1234 reports? Yeah. Any Commission comments? Well, I have just one comment. It is basketball season, so I'm going to remind the public that every Friday night at your local high school, there are wonderful games to attend and see. So I'm encouraging you to go out there and support one of our local high schools. With that, this meeting is now adjourned, and we'll be back here for our next regularly scheduled meeting. And thank you and good evening. February 22nd.